if the accused statement, the statement of the accused under section 313 is to be done, then if the Metropolitan Magistrate is recording such memorandum, then he has to record the memo of substance in question answer form. So basically, no, he has to record only the memo of substance. But if it is not a Metropolitan Magistrate, that means a Judicial Magistrate First Class or Sessions Court or any other magistrate or court, then they shall do it in question and answer form. So only the Metropolitan Magistrate is allowed to record a memo of the substance, and others will, while carrying out a 313 statement, have to record it in verbatim in question answer form. Then comes the fact that it will be always, it should be recorded in the language of the accused, and if it is not practicable, so basically if the accused is speaking Telugu, then if the presiding officer does not know Telugu, in that case it is not possible to record the same in the language of the accused, then in that case it shall be recorded in the language of the court. And if it is done, then it will be the record will be shown to the accused, it shall be read over to the accused and interpreted if he does not understand, and then he shall explain the same, and he can also amend the answers if it is necessary. Then he will sign the same, the judge will sign the same, and certificate that it was read over to him and he understood the nature of it, that will be affixed, and then it will be done. That is the provision of accused statement. Now another provision in 282 says that interpreter of the court. So basically, if the court does not understand the language of the witness or the accused, then in that case an interpreter can be fixed. So if that is done, then the interpreter is bound to state truthfully whatever he actually hears. So basically, I had seen in his speech that Rahul Gandhi, while addressing a gathering, was speaking in English, and there was a Telugu audience, and the interpreter was actually going on and speaking anything from his mind. So that cannot be done in the case of a court proceeding, and the interpreter is actually bound to state truthfully. Now it says that the High Court can make its own rules for recording of evidence or accused statement, which is in fact done, because the GRCO, if you'll read them when you'll be in the course of your practice or profession, as the case may be, GRCO is actually made for the purpose of making sure that there are provisions which say that there are rules for recording evidence, and those rules can be followed. Then comes commission. So this is also another typical provision, which is that whether if the court, so basically there are many cases where the court will be requiring that a commission should be issued for the purpose of for the interest of justice. In what cases it shall be done? First is, if I'll give you an example. If the person or the witness is bedridden, so in that case, if the person is bedridden, then he cannot come to the court. So basically, the court has, there is this dilemma that the court cannot go. So now the court has this provision, enabling provision, that it can go and issue a commission. So when it is to be issued, that if the witness's examination is necessary, but it cannot be procured without delay and inconvenience, or it is expensive to procure the attendance of the witness, then in that case the court may dispense attendance and issue a commission. So court in such cases can issue a commission. If the prosecution witness, it is it has to be examined, and in that case the expense of the accused is to be paid, the pleader to be borne by the prosecution, the expense of the accused or the expense of the pleader, both have to be borne by the prosecution. So basically, if it is a prosecution witness which has to be examined, then the expense of the accused along with the expense of the pleader are to be borne by the prosecution. So in what case it is mandatory to issue a commission? So for examination of president or vice president, an issuance of a commission is mandatory, because they are very high dignitaries. So for that reason, for their examination, if their evidence is required in a case, then issuance of commission is mandatory. To whom the such commission shall be issued, that is enumerated under section 285. So it says that if within the territory of the code, then it will be issued to the chief metropolitan magistrate or the chief judicial magistrate. So basically, if it is the a witness is within the territory of the court, then it will be issued to the chief metropolitan magistrate or the chief judicial magistrate. But if the witness is within India but the court does not extend, so basically if it is extending, if it is in Jammu Kashmir or Nagaland or wherever the court does not extend, then an officer appointed in this behalf by the central government, they can it can be issued to them. Now comes yes, if it is outside India, then as prescribed by the central government. And commission how executed? So basically, it is saying that the court to whom the commission has been issued, it can appoint and proceed to the place and then take down the evidence, and then the opposite parties, they may examine the witnesses. They can actually prepare interrogatories and they can put them to the witnesses. They can cross-examine and re-examine if needed, and then return to the commission after the examination. It shall be returned to the original code, and after inspection, they will be allowed to be a part of the record. So this is the rule, and during such time, the adjournment will be allowed, and this also applies to foreign commission. Now another short topic, that is affidavits. So section 295 297 says that if there are allegations against conduct of public servants or evidences of formal character, then in that case, such evidence can be given in the form of affidavits. Also, you must be knowing in NI cases, in evidence can be given in the form of affidavits, except if it is scandalous or irrelevant, then in that case, giving evidence by mode of an affidavit will be a good way. Also, affidavits are to be sworn before a judge or a judicial magistrate or an executive magistrate or commissioner of oath or notaries appointed on that behalf. So affidavits also, they are to contain that the statements that are made, those are true to the best of the knowledge and belief of the person who is making such affidavit. So this is another, this actually ends the discussion on inquiry and trial. I tried to cover as many important provisions as possible. Now we'll go to the other three small topics for today, that is judgment. So after inquiry and trial, there should be a judgment. After that, we'll discuss another two things, that are plea bargaining and limitation for taking cognizance. And with that, our class will be ending. So max it will take me another 20 minutes. So judgment, as we all know, section 353, 354 says, what do you mean by judgment? It is nothing but a final decision of the court. So judgment is a final decision of the court along with reasons which determines the innocence or guilt of the accused. So this is the definition, though it has not been given anywhere in the code. Still, for the purpose of your reference, you should know that this is nothing but a final decision of the court. If it is not the final decision of the court, that will not be a judgment. It will just be an order. But if it is a final decision of the court without reasons determining the innocence or guilt of the accused, which is actually resulting either in conviction or in acquittal. Of course, acquittal does not mean that it will be discharged. Discharge does not signify an acquittal, as we have discussed time and again. So if that's the case, then it will be presumed that it is a valid judgment. Essentials of a valid judgment, the essentials are that it should be given in open court by the presiding officer and after conclusion of the trial. It shall be signed by the presiding officer, dated by the presiding officer in all pages. The copy of the judgment shall be given free of cost to all the necessary persons who are applying for a copy. Uh, Another uh, essential is that if the accused, if he is in custody, then he must be uh, brought to the brought before the court, and the judgment should be pronounced in presence of him. But if he is not in custody, then he shall be summoned to be appear before the court. And if his 205 has been allowed, that means if his attendance has been dispensed with, then it is fine, and he shall be summoned and he shall be called. But though this is a mandatory provision that accused should be present, but just because of the fact that the accused was not present, that will not be vitiating the judgment as such. And even though if there are more than one accused, then if the court is of the opinion that procuring their attendance will cause undue delay, in that case judgment can still be delivered if there is just one accused or some of the accused. So it should be in the language of the court. It should be in the language of the court that we discussed. What should it contain? It should contain the points for determination. It should contain the decisions and the reasons for such decisions. It shall contain the offense under which the allegation has been made, the section of law, the quantum of punishment. If the judgment is actually suggesting that there should be an acquittal, then such acquittal from which offenses are being done, that shall be mentioned. If there is a doubt that which section of IPC the offense should be punished, basically if the judge is unsure that whether there is a 392 or 394, then he can express the same and the judgment, and he can sentence in alternative. One of such sentence can be imposed. Then if the judgment has to mention as death, so basically if the judge of the opinion that a sentence of death should be imposed, then that should be for special reasons. And in numerous apex court judgments, it has been given what are special reasons. Basically, the rarest of the rare doctrine, that must be if that the court is of the opinion that the death penalty has to be imposed, then it shall be reflected as well. And if it is actually he is actually of the opinion that a death penalty has to be prescribed, then it shall be mentioned that he shall be hanged by neck till death. And in various apex court judgment, it has again been held that such act of hanging someone till death is actually not ultra vires of Article 21, because of the fact that for some reason that I am unaware of, the honorable court is of the view that hanging someone and killing is probably the most painless way to kill. But I do not know. I probably do not agree as well. But then, if the honorable court has actually held it in many cases, so let's just for now, India prescribes this mode of death, infliction of death, that is hanging someone by neck till death. Now, another important provision of judgment is that if the sentence is up to 1 year and the judge actually prescribes a punishment of for less than 3 months, then the reasons are to be recorded. Why did he go to punish him for a period of less than 3 months? But if the sentence is that he should be in detention till rising of the court, then in that case this provision does not apply. Or in summary trial cases also, this provision does not apply. Another important essential of a judgment is that it must be self-contained and it shall be a speaking order. Now coming to judgment of Metropolitan Magistrate. Now we all know that Metropolitan Magistrate's judgment, Metropolitan Magistrate's evidence, accused statement, all are done pretty in summary way. So basically, some they tend to skip the nitty-gritties of the orders. So what all these are to contain? it shall contain the serial number of the case, it shall contain the date of commission of the offense, it shall contain the name of the complainant, it shall contain the name of the accused, father's name of the accused, residence of the accused, offense alleged, plea of the accused, examination if it has been done by the accused, then it shall be mentioned. The final order, what does it say? That will be there. The date of such order will be there, and if there is an appeal lying from such order, then a brief description thereof also shall be mentioned. Now coming to compensation under section 357. So these provision makes it clear that there can be a provision of compensation for victims, and the fine recovered can be actually applied towards compensating the victim or the expense of prosecution or separate compensation by court or appellate court. So basically, either separate compensation can be awarded, also the fine which has been recovered, that can be also applied towards compensating a victim. So that does not mean that you will be escaping the liability under tort. So basically, just because you paid compensation under section 357 does not mean that you will be escaping the liability under tort. So basically, if there is Fatal Accidents Act or any other act and you are liable to pay damages under that, just because you paid a compensation under this, it will not make sure, or it will not help you in winning the cause that you will not be paying the compensation again. But yes, civil money suit if it has been filed. So if basically in defamation case, if a money suit has been filed for defamation, and then again an offense under section 499, 500 or 512 as the case maybe has been filed, in that case, such civil suit, whatever the compensation has been given, that can be taken into account. This new provision of victim compensation scheme that has come into a picture with the recent amendment, which is enumerated in 357 to A to C. Basically, it says in nutshell, we should know that the victim compensation scheme will be formulated by state government in consonance with the central government, and they'll make the scheme, and the district legal services authority will determine the quantum of the compensation. And if the accused is not traced, then in that case the compensation can be also sought for from the state. So basically, even though there is an offense committed, even there is a murder and the accused in fact was not traced, then also compensation can be claimed from the state. So another provision is there which says that if in acid attack cases or rape cases, the compensation must be in addition to fine. So while in other cases only fine and imprisonment can be a good way to go, but in acid attack cases or rape cases, fine along with the compensation must be imposed. Next is treatment of victims in rape cases. That is, there is provision which says that the rape cases victims, that treatment will also be covered by the state law. Another section which deals with it is that if there is a groundless arrest, then they can be compensated. Now coming to provision of good conduct enumerated in 361, but we don't have to discuss as it is not applicable in the case of Odisha, as Odisha has a special act of Probation of Offenders Act which they have adopted, and Probation of Offenders Act is applicable. So by virtue of that, 360, 361 are not applicable in the case of Odisha. 362 speaks that court will not alter the judgment, and 363 is that the copy of the judgment is to be given to the accused and others, and 364 says that if it is not in the language of the court, then it shall be translated to the language of the court. 365 says that the copy of the judgment will be given to the DA. So this, in a nutshell, completes judgment. Now coming to plea bargaining, though it is frequently asked, I do not think that there is anything that will trouble you. However, we'll discuss them, that we have to know. So basically, it's a negative clause which has been made, that in which cases plea bargaining are not applicable. So plea bargaining 265A says that plea bargaining is not applicable to offenses punishable with death, punishable with imprisonment for life, punishable with imprisonment for 7 years or upwards, in socio-economic offenses as determined by the central government, offenses against women, offenses against children below 14 years. In such cases, plea bargaining provision will not be coming into picture. How the plea bargaining application and then application under plea bargaining will be done? That it shall be done before the trial court, and what it has to contain, that it shall contain the brief description of the case, it shall also contain the offenses concerned, it shall also contain an affidavit sworn stating that he is preferring that the accused is actually preferring it voluntarily. So it has to state that he is, so the voluntariness of the statement of the accused is a mandatory clause in order to make sure that if the provision under plea bargaining can be validly attracted. So that he has actually understood the nature and extent of the punishment, and that he has no previous conviction. That must be contained in the affidavit, and then the if such affidavit is filed along with the application, then in that case the PP or the complainant, as the case may be. So basically, if it is a case instituted on a police report, the PP will be given a notice, and if it is a case instituted on a complaint, and in that case the complainant and the accused all will be given a notice, and they will be asked to appear, and the accused will be examined on camera, and the court will ascertain whether the statement or the fact that the accused is actually preferring plea bargaining, whether it is a voluntary one or not. If the court is finding that it is a voluntary one, then the time will be given to both the parties, that is the PP or the complainant on one side, as the case may be, and the accused on the other side, that they will together basically, what do you mean by plea bargaining? I forgot to explain you that it is nothing but a bargain. It is nothing but a bargaining provision, that because of the fact that it is the offenses is of less serious in nature, and if the victim or the complainant have no problem if the offense is the offender is not punished as such, just to make sure the burden of the court was is all work is also lessened. Also, probably compensating the victim will be a better way to go about it than actually going ahead and punishing the wrongdoer, because it will not serve any purpose. Actually, the principle, it will be followed. The eye for an eye principle will be followed, as Mahatma Gandhi said, that it will result in this fact that the whole world will be blind. So, as far as possible, if it is not a serious offense and it is not affecting the public at large, in that case, it will be the plea bargaining provision shall be allowed to come into picture, and those will be dealt with under this provision. So now we discussed that if it is voluntary, then they will be given a time that they will go into an agreement which will be called a mutual satisfactory disposition, and it will also include the compensation to the victim, whatever the punishment will be imposed. So they in fact will decide within it, they can actually bargain with each other, and the court will in fact facilitate it. So, but if it is involuntary, then, or there is a previous conviction of the accused, then it will not be done, and it will be taken as if such plea bargaining was not. But what if it was voluntary? Then a mutual satisfactory disposition will be done, and if a mutual satisfactory disposition will be done by a PP complainant on one side and accused on the other side, then in police report cases, that means in a case which is instituted on a police report, then the PP, the investigating officer, the victim, the accused, all they shall be issued notices, and then the court will also ensure that there is voluntariness of all stakeholders. That means whether the PP is voluntarily doing it, whether the IO is voluntarily doing it, whether the victim is voluntarily doing it, the accused is voluntarily moving it. So no one should be under any duress. That has to be made sure by the court. And once the court makes sure that all of these have been done voluntarily, then in that case, the plea bargaining will be proceeded. And here, accused may participate along with his pleader. So it will not be a bad reason if he participates with his pleader. In complaint cases, victim and complainant. As I discussed in the case instituted on the police report, PPIO, victim, accused, all will be called. But in complaint cases, the victim and complainant, that means the complainant, if the victim, they are different, then both will be called. If they are the same, then one person will be called along with the accused, and they can participate along with the pleader. And then a report will be prepared by the court along with the mutual satisfactory disposition and the observation of the court on that whether it was a voluntary one or not. And then all the stakeholders will sign it, and after that the court shall go ahead and dispose the case. And how it will dispose the case? After actually making sure that compensation to the victim is awarded, punishment is accused to be also decided, that because here either the punishment can be completely waived off, but there is this chance that some punishment can be awarded. In that case, whatever is the case, that will be mentioned. Then probation of good conduct, if that is being extended to the accused, then it will be reflected in that, and the court may release accordingly. And it may provide half of the punishment if there is a minimum punishment prescribed. So if there is a minimum punishment prescribed for an offense, so basically in IPC there are many cases in which it has been written that he shall be punished with minimum of this. Then in that case, a minimum punishment, if it has been prescribed, then half of such minimum punishment has to be given. And if no minimum punishment has been given, that means it may extend to one year, it may extend to 3 years, or whatever the case may be. Then in that case, 1/4 of the punishment prescribed, that will be given to the accused. And then the judgment will be made, that is whatever the judgment, that will be made in the open court, and it will be signed by the presiding officer. And another thing you have to remember, that if there is a plea bargaining and successful judgment has been done, then it shall be final, and no appeal will be lying against that. But of course, if there is no appeal, then also there is writ and 136 special leave petition coming to your rescue. So whenever I say that, whenever there is this clause coming that there are no recourse available to any party, so it will just mean one thing, that there is special leave petition allowed, and also writ allowed in such cases. And then power of the court, it has been given in 265H. It is not that important. Then the period of detention, whatever the period of detention that the accused has already undergone, those period of detention will be set off. They will be set off. The period of detention, whatever he has undergone, they will be set off. And another important element is that this part of this chapter, it will actually override the code. So that means, so even when if there is any inconsistency between the chapter and the code other chapters, then this chapter will override the other chapters. Now 265K says that statement of accused not to be used for any other purpose. Basically, if the accused actually makes a plea bargaining application, whether it is successful, not successful, that is to be seen at a later stage. But that statement that he had made, those cannot be used for any other purpose. So basically, just because he confessed that he has committed the crime, and because he made a plea bargaining application, no. So in that case, you can't say that you will record the examination of the accused, and you will record the confession of the accused, and you just will go ahead with the conviction of the accused. You can't do that. Also, no application for plea bargaining will be allowed in cases of juveniles or children. This is another provision. And with that, the provision of plea bargaining also somehow comes to end. Now the last topic for today, that is limitation for taking cognizance of certain offences. So 467 and 468 mention about the period of limitation. 467 says that the period of limitation will be nothing but what has been defined in 468, and 468 actually defines the period of limitation, that is that 460 according to 468, if the punishment prescribed is fine only, then the period of limitation is 6 months. That means beyond 6 months, uh, if the punishment prescribed for that offense is fine only, then beyond 6 months, cognizance cannot be taken. And if the period of imprisonment is up to 1 year, then beyond 1 year, then that cognizance cannot be taken. And if it is more than 1 year but less than 3 years, then in that case, uh, beyond 3 years, cognizance cannot be taken. Now we'll discuss that whether it is applying to the filing of the case as well as the cognizance. It actually applies to both filing of the case as well as the cognizance, but there is this discretion of the court that uh, though we are saying that these are the limitation period, still then the court has the discretion to actually extend the period of limitation, and even though the limitation has expired, still then the court can very well entertain a petition, because ordinary rule is that the criminal cases should not be having any limitation, because this is not an offense against a private person but an offense against the state. So this another thing is that whether it is in respect of the offense charged or the offense finally proved. So basically, so if there is a so I'll give you an example that the uh, first the cognizance was taken uh, on the uh, allegation that a murder was committed, or 307 was committed, not murder, attempt to murder was committed. So the limitation here will not apply. So here the cognizance was taken even after 10 years, for example, 10 years the cognizance was taken. But finally, when it was proved, the at the time of judgment, it came out that it is just a case of 325, 323, 323, for example, just simple. In that case, it is not more than 3 years. So that means within 3 years, the period of limitation has expired. So whether the cognizance being taken after 10 years is a good cognizance or a bad cognizance. In state of Himachal Pradesh versus Tara Dutt, it was held that it will be a good cognizance as it is in respect of the offense charged and not in respect of the offense finally proved. Then computation of period of limitation. How the period of limitation is to be computed, this is another matter that we'll discuss. That is, the period of limitation will commence on the date of offense. Ordinarily, on the date of offense, the period of limitation will commence. But if the date or the accused is not known, basically, if the date of the offense or the accused person who has committed the offense, these are not known, then in that case, the first day when it comes to the knowledge that whether this is the person who has committed or this is the day the offense was committed, then the first day when it comes to the knowledge of such uh, uh, the fact of such knowledge coming into uh, the uh, picture, that will be considered. Another rule is that the first day will be excluded. So basically, the day from which such computation is to be done, that will be excluded. Uh, then we had also discussed that delay can be explained, and if it is uh, in due diligence, in good faith, on same facts, and another prosecution. So basically, this is saying that if uh, just because he was in good faith, the prosecution in good faith was prosecuting the same case in another court. On the same facts, in good faith, he was prosecuting in another court. So there was a time gap because the time was actually spent in a wrong court. So that time will also be excluded if it is done in good faith. If the matter is somehow stayed, then such period of stay that shall also be excluded. Then if the notice, consent, or sanction period, for example, a sanction of government or the DM is necessary in case of Arms Act. to take cognizance in an arms act, the sanction of the DM is lesser. So basically, if there is such notice, consent, or sanction is to be obtained, then such period of obtaining that sanction, that period spent in obtaining that sanction, that will be excluded. But when we say that the period of obtaining sanction, that will mean that the date of application of sanction and the date of receipt of order, these are excluded from that period, and hereby they are included into this period of limitation. This is a confusing thing, so I'll explain it again. So basically, if I'm saying that whatever period of sanction that was spent to obtain the sanction, the period that was spent to obtain the sanction or consent, that will be excluded. But the date of application of sanction and the date of receipt of order of such sanction that it was actually granted, those 2 days, they will be excluded from the period of sanction, period which was obtained, period which was necessary to obtain the sanction. So if that was excluded from that period, then they will be included in the period of limitation for this purpose. So the sanction period will be excluded, but the date of application and date of receipt will be included again. And if the accused is absent from India or absconded from India, then in that case, such time he was absent from India or absconded, that time also will be excluded. Another important provision in 471 says that if the court is actually closed on the date of the expiry of the period of limitation, then the court can take cognizance on the reopening date. And just because the period of limitation expired, if the court was actually closed on that particular date, it will not be presumed that the court period of limitation is over, and 1 day grace will be allowed. Next provision is that if the offense is that of a continuing nature, then a fresh limitation period begins to run at each such moment the offense continues to happen. For example, if a cruelty is being committed in respect of a wife by a husband, then from each day, fresh period of limitation will commence. So you can't say that from the date of marriage, the limitation period will be completed. So then, if delay is properly explained or the court is the opinion that it should be allowed in the interest of justice, then the court can still go ahead and take cognizance. This is nothing but an enabling provision. With this, we end our discussion for today. We are open to questions if there is any. I hope there won't be any question because there was nothing really to actually really difficult to understand. Though if you just can understand simple English, that should be sufficient for you to enable you to understand the provisions. Even then, if you have any questions, you may pose them. I believe there are no questions. Okay. We'll end the discussion here, and next class will deal with appeal and reference and revision. Thank you.